And what that means is it gives you an opportunity to do the discovery regarding whether there is a basis factually to sustain a claim for punitive damages. How is your client prejudiced if this were to be granted at this stage? I know you said that there was no notice, but they would be able to get the financial information as if they can show or sustain a motion for summary judgment or a motion to dismiss. Is that now I'm going to grant this second amended motion to amend rather.
And candidly, that's because it would reward 13 months of defiance of the spirit of this court's March 3rd, 2025 ruling.
All rise. Chancery Court of Cheatham County is now in session. Honorable Judge capable of presiding. God bless the courtroom. Great state of Tennessee. God bless the United States.
Sully, did you unmute us?
Be seated, please.
All right, good morning. I'm going to take up a chancery matter first that we have some urgency to. So, all right, Ms. Roberts, if you can hear me, I need you to, I don't know if you need to start your video or if you just need to make sure you're unmuted, but my understanding is that we have some matter in the justice versus justice case I need to address. All right, this is your motion to withdraw, Ms. Bloodworth.
Yes, it is, Your Honor. Thank you. This is a divorce matter, and there's nothing pending. There's not a final hearing set. And we have a fundamental difference on how to proceed, and that's the basis of my motion of withdrawal. I did notice up my client for 9 a.m. I don't see him here. I did check with the other in the other courtroom, and I did not see him here. I did tell him his presence was necessary. And Ms. Roberts may want to be heard as well.
Ms. Roberts, you have anything to add to this?
Yes, Your Honor. I just want the record to be clear about the fact that Mrs. Bloodworth and I had this matter scheduled in front of Judge Turnbow on some various motions that I had filed. We had gone back and forth with our clients, and we had reached an agreement that I had typed up on my computer. We asked Judge Turnbow to take a recess so that we could go over the order. We thought it would be more expeditious for us to use the courtroom, have them both sitting there for us to go over the order to make sure both of them understood what we were entering into court. Judge Turnbow was gracious enough to leave the bench, and we started to, and I was reading over the order to both of our clients. Mrs. Bloodworth's Mrs. Bloodworth's client, Mr. Justice, became verbally combative. He hurled a number of insults, personal attacks at me, to the point at one point in time, he actually asked me to come and let's take this outside and settle it. At that point in time, I asked the bailiffs to come back into the courtroom. The clerk, as well as our court reporter, are all witnesses to the actions of Mr. Justice. He became verbally combative with his attorney, making comments to her. We had the court designated accountant there, and he made comments to her. And so it was a very inappropriate situation to take place. In hindsight, I probably should have asked that he be arrested for the threats that he made towards me personally, but it was a extremely bad situation. I have contacted the Board of Professional Responsibility over what had transpired, just to get guidance as to the fact that the actions that Mr. Justice displayed in court personally against me, whether or not it was a situation that I became a hindrance to my client, and because he had attacked me personally about things. And so I'm waiting on an opinion on that, but I just don't see it. Again, Ms. Bloodworth has justifiable reasons to withdraw because of her client's actions.
Your Honor, if I may, the depiction of events is accurate as described by Ms. Roberts. I wanted to have that on the record as well. And I have an order for the court's consideration. I don't know how many days Your Honor would allow him to retain new counsel. I did leave that blank.
Well, we'll give him, I normally provide 30 days to retain new counsel, so I'll add that.
Yes, sir.
Ms. Roberts, if you determine from the Board of Professional Responsibility you have the duty to withdraw, then you just simply file your motion to submit an order.
Yes, Your Honor.
Ms. Bloodworth, I have granted your motion to withdraw.
Thank you, Judge.
Thank you, Your Honor.
And that is all we have for Chancery at the moment. We have 10:30 for Chancery. But thank you for coming up. Okay, welcome to the Circuit Civil Docket Call for Cheatham County in our brand new courtroom. First time that we'll have held the Circuit Civil Docket Call here, and so we're thankful for having such a nice courtroom. I told somebody the other day that I felt like I was on the bridge of the Starship Enterprise when I sit behind this desk and in this chair, but I'm thankful that we have a better sound system and a better lighting and so forth. I love the old courtroom, but it is difficult sometimes to conduct business because of the acoustics, if nothing else. So we are ready to call the docket, so you may call the first case. That's on the state of Tennessee on behalf of the Commissioner of the Department of Transportation.
Mr. Todd had contacted our office just a few minutes ago and said that he was not aware that he had to appear today and would not be able to be here.
It's just a review on an agreement. As far as I'm concerned, you can set it for your next civil.
There is another one behind that. It's 6855.
State of Tennessee Department of Transportation versus Judith A. Garcia Alvarado. Motion to substitute the defendant Cardinal Financial Company LP to PNC Bank. Anyone here in opposition to that motion? No opposition, we'll grant that motion. You can reset the review if you want to for next Circuit Civil Docket Call.
Docket number 6966, Ruben Vega versus William Lane et al.
Yes, Your Honor. Dale Crowley, Nashville Bar. We imagine that will be 10 to 15 minutes of argument.
All right, let's take it up.
in the response in opposition. As to the undue delay, Your Honor, which is the first factor, this is a double-edged sword for plaintiffs. We've had about a dozen of these motions already this year, Your Honor, where trucking companies are opposing our motions to amend to bring more additional claims and direct negligence claims against trucking companies. On one hand, if we bring it too early, we get a response saying that there's not sufficient enough facts for this amendment, that is futile, and that there's been no notice of these types of amendments. Well, at the same time, Your Honor, if we wait too long, we receive a response that says that there's been undue delay and prejudice because we haven't brought it soon enough. So, Your Honor, we're trying to find that sweet spot where we can bring these motions with enough facts to actually make a valid, cognizable claim, while at the same time having these granted. So, Your Honor, the facts that we discovered were in December, so we filed this motion about 4 or 5 months after we received the discovery responses. It was originally our plan to do the party depositions to get this sworn testimony into the record to further support our motion to amend. Since it was taking a little bit longer to get those depositions set, Your Honor, we made this motion just out of an abundance of caution to get the punitive damage claim in the complaint. So, Your Honor, as to that factor, we don't believe there's been any undue delay. The second factor is a lack of notice to the opposing counsel, Your Honor. Respectfully, the information that we are pointing to, the factual information for these claims, were in the defense sole control. That they knew that they had already hired this driver, fired the driver, and then hired him again before this collision. So we don't believe that there's any lack of notice about the facts underlining our punitive damages claim. As to bad faith, Your Honor, there was not a argument presented in the response about bad faith. There is, I believe, a one-sentence explanation saying that due to the undue delay, they allege that there could have been bad faith behind the scenes of why we were waiting to make this amendment. So I figured I would address that, Your Honor, but as a factual basis, there's not really anything pointed to us that we have acted in bad faith. As to repeated failures to cure prior deficiencies, Your Honor, like I said, we have had one prior amendment. It was 2 weeks after our original complaint just to correct the names of the parties based on that police report. So we don't think that we have had repeated failures to amend our complaint. As to the undue prejudice that is addressed in the response, Your Honor, there is no prejudice to opposing parties here. We are early in discovery in this litigation. There is no trial date set. We have not taken party depositions, and written discovery is still open. So, Your Honor, because of that, we would argue that there's no undue prejudice if this motion is granted and we get to do some additional discovery on that punitive damages issue. And then as to futility, Your Honor, we do believe that this punitive damage claim has weight, that a jury is going to be able to hear these facts and determine if this defendant company consciously disregarded the threat of having this driver on the roads. The argument against us on this one, Your Honor, is going to wait. Opposing counsel has claimed that the facts as we know them right now are not enough to have the jury award beyond clear and convincing evidence for punitive damages. As Your Honor knows, the reason we have discovery is to find additional facts and support that claim. Since we're before the party depositions and more written discovery about this specific punitive damages claim, we think that even at this point, we have a good claim, and that it's not going to be futile when more discovery is able to boost up our claim for this, Your Honor. So for those reasons, we would ask that the motion to amend be granted.
All right, from the defendant.
Your Honor, Corey Chilwood here for the defendants. I just want to point out initially the dates of all these things. Defendant Beacon submitted its discovery responses on December 18th, 2026. Then 5 months later, plaintiff filed the current motion to amend on May 13th, 2026. That's about 5 months, and we would submit that that's undue delay because in the Bodine case submitted in our response in opposition, there was a 4-month delay that was found sufficiently long enough to find undue delay. And the Tennessee Court of Appeals has repeatedly emphasized the necessity for efficient, speedy, inexpensive resolution of cases. And under the futility factor, which I would believe is the second most relevant factor here, I think it's important to highlight that the Tennessee Court of Appeals has defined futility not only as where it would not withstand motion to dismiss for failure to state a claim, but also where granting the amendment would prolong the litigation, but not lead to ultimately to a different outcome. Here, we're litigating the issue of amendment, then we'll be presumably litigating, conducting discovery on the issue of punitive damages, even though punitive damages, in our opinion, would not get to a jury in this case. Part of the basis for plaintiff's motion to amend is that defendant, the driver, was exceeding the speed limit by 8 miles per hour. And then insofar as plaintiff relies on the fact that the company hired the driver after previously suspending or terminating him, I would say that there's just that fact alone doesn't necessarily give rise to a claim of punitive damages. Plaintiff also has to establish the intent required for punitive damages. And here it looks like the intent they would be relying on would be intentionality or recklessness. But simply hiring someone that worked for you before or speeding 8 miles per hour over the speed limit is, Your Honor, I don't think gives rise necessarily to an inference of recklessness. As far as prejudice goes, allowing punitive damages to proceed opens the door to invasive discovery of financial information. Both defendants that really probably is not relevant to this matter and could be used in bad faith. And based on the facts that were available to us and the time span that's occurred, 5 months between the submission of our discovery responses and the filing of the present motion to amend, we didn't really have notice that there would be a punitive damages claim here. And so because of those three factors, namely undue delay, the futility, and lack of notice, we would submit that plaintiff's motion should be denied. I also want to note that there's no hardship to plaintiff if this motion is denied, because if more facts come out in discovery that would give substantial weight or noticeable weight to a punitive damages claim, he can remove to amend. Like you said, depositions haven't occurred yet, so if something were to come up there, they can still, move to amend based on any information that comes out there. And also, it's denying the motion to amend doesn't preclude compensatory recovery for plaintiffs. So there's not substantial hardship on plaintiff if the motion is denied.
How is your client prejudiced if this were to be granted at this stage? I know you said that there was no notice, but I think, go ahead.
Yes, Your Honor. So if you'll allow me, he was kind of talking about their MO, things that they typically deal with in these cases with the trucking companies. So in my experience, once this punitive damages claim is allowed to proceed, plaintiff's attorneys like to submit discovery requests probing financial information, which can be particularly invasive. And so I would submit that would be the primary basis for prejudice in this case.
So if I allow them to amend their complaint, but put an order down that says they cannot submit financial information, financial discovery to your client to prove on the damages part of it, but they can amend it, and then we get to the point where the only time that they would be able to get the financial information is if they can show or sustain a motion for summary judgment or a motion to dismiss. Does that make any sense to you?
Yes, sir. You're talking about placing conditions on the amendment?
Right. I'm just saying, if I granted their motion to amend, but prohibited them from submitting discovery requests on the financial aspect of it to protect your client's financial until there's established a sufficient basis for a belief that there is a claim for punitive damages. I mean, obviously, before you get to a jury, you're going to have to, if a punitive damages claim is sustained, then you're going to have to allow them to have that kind of discovery. But I'm just suggesting, because you say it's early on.
Yes, Your Honor. I think that would substantially mitigate the prejudice if that condition was placed, yes.
Are you okay with that?
No objection from us, Your Honor, on that issue.
Seems to me that's the logical way to do it. I mean, we are operating under a system that we liberally grant motions to amend, and I think the first motion to amend, as was pointed out, was done before any defense counsel was present in the case, and under the rules they had a right to amend it before a responsive pleading. Now I'm going to grant this second amended motion to amend, to allow them to add the punitive damages claim, but put a restriction on their claims or the discovery request as to any financial matters until they obtain leave from court to pursue that. And what that means is it gives you an opportunity to do the discovery regarding whether there is a basis factually to sustain a claim for punitive damages. And only after that is demonstrated to a court. It doesn't have to be me, but it could be any of the judges. But once that has been established, then you can do your discovery if necessary.
All right.
All
Thank you.
Thank you.
Thank you, Your Honor.
You're going to draw the order for me?
Yes, Your Honor.
All right. Excuse me. All right, call the next case.
Docket number 7044, Gelato Wayne Creel versus Anna Cabana and
Good morning.
Good morning, Your Honor. This is an appeal from General Sessions Court. I represent the plaintiff in this matter.
All right, so this is basically an appeal that's here today to get a date for a hearing.
Your Honor, I believe we're going to need to engage in some discovery. So if we could set a review date sometime in the future so we could.
You want to set it off a ways to do the discovery? Is that it?
Yes, Your Honor, please.
Does it matter who hears? Any of the judges have a conflict?
No, Your Honor. Not from the
How long
plaintiff.
do you think it's going to take to do your discovery?
There's been no discovery in this matter prior to. I would think somewhere between 60 to 90 days would be reasonable, but I expect a couple of depositions and some requests for documents. So I could have that done within 60 to 90 for sure.
Well, we rotate in here every 4 months. So
Okay.
if you're wanting,
So we look 4 months out then?
I'm here in November, correct? And who's here in December? So you got me in November and Judge Wallace in December.
I'm out of the country in December, Your Honor, so the second works great for me.
That day looks great, Judge.
How long do you think, once we get into it, how long is it going to take to try this case?
A day.
A day, half to a day,
Half a day?
or up to a day, probably max.
Well, that would be normally on the second day of November, which is our circuit civil docket call, and we would just take it up after the, does that work for you?
Yes,
So
Your Honor.
9 a.m.
9 a.m.
around 10ish probably.
Well, it'll be following, it's 9 a.m. following the call of the civil docket, so it will be the first contested case. I know, we're gonna have to let them know they can't set very much, so, thank you. All right, we'll set it for 9 o'clock on the November the 2nd.
Thank you, Judge.
Thank you, Your Honor. I have nothing further. May I be excused?
You may.
Thank you so much.
All right, call the next case.
Docket number 7054, Pleasant View Utility District of Houston County versus John Edward Henderson and Megan Elizabeth.
This is a petition for land condemnation.
Yes, Your Honor. And I represent the Hendersons in this matter.
And I'm Dewey Brandstetter, and I represent Pleasant View Utility District. And we have reached an agreement on possession, and we anticipate submitting in the next couple of days an agreed order of just as to possession, not as to the damages for the property. But we've worked it out, Ms. Snow and I have, and so I think we'll be able to submit an agreed order.
Okay, you're just going to submit an agreed one.
Yes, Your Honor. And my clients are still here, so if I could just make a brief announcement.
Sure.
Sure, yeah.
As to their agreement. We are going to agree to the 20-foot permanent easement on the 10-foot temporary easement. We're going to agree on that. However, there is a septic line that is located in part of that area, so the 10-foot will only be the area where the septic is not located. And there will be a 5-foot clearance on around that. And then we also talked about a 5-year warranty to ensure that there's no damages to the septic. And then we're going to put some kind of self fencing around the septic area. And then we'll just reserve any compensation and damages for
All
later
right.
pay.
Represents the agreement, then I'll approve that agreement.
Good.
All right.
We'll submit an agreed order.
Thank you. Mr. Branstetter, you have a next one as well.
I do, and I'll, if I may, this is Amanda Hoffman, which is case number 7055, also a condemnation case that we're here for possession on. Ms. Hoffman has not responded. She did not respond to the initial inquiries from the district. In fact, Mr. Stephen Ayers, the general manager of Pleasant View, is here. We then filed the lawsuit, petition for condemnation. It was served on her on June 3rd. She did not respond to that. I sent her a copy of the short memorandum that was submitted to the court last week. She did not respond to that. We don't anticipate that she will ever respond, but more than 30 days has passed. And so under the condemnation proceedings,
You're entitled to possession.
we're entitled to possession. I've submitted a proposed writ. I've also got one here that I could then actually serve on her today. The one that I submitted was just a proposed writ, but I've got the same document, an original, if Your Honor prefers that.
As a matter, I've got the one that you had submitted as a proposed. If you have the original, you can submit that to the bailiff.
Yes, I'll submit that to the bailiff, and then I will send her a copy. Let me go ahead and sign the certificate of service, and I will do that today, Your Honor.
All right.
And it's just a proposed writ of possession that allows us the right to enter her property, and it's for the purpose of constructing a water line. And Your Honor, the urgency, the reason we went ahead and filed these condemnation petitions is originally the district Pleasant View had anticipated being able to put the water line in the right of way. As it turned out, there were other utilities, AT&T, Comcast, and so it was not possible to get it in the right of way. So they needed private easements. They're under a time crunch because they've got ARPA, American Recovery Plan Act money, that they have to do this work before the end of September. So that was the urgency for filing these petitions.
All right. Well, I've signed your order.
Good. And I will send her a copy and appreciate it. Thank you, Your Honor.
Thank you. Go ahead.
Docket number 6682, Cordova versus Robert Martin.
Good morning, Your Honor. It's ready for argument.
All right.
Discussion. Your Honor, respectfully, I filed our motions first. I think the plaintiff should be heard in this matter first.
You filed yours first, and you may go first.
Thank you, Your Honor. Your Honor, this morning, I think the best way for us to handle this, there's 4 separate matters on behalf of the plaintiffs and 4 separate matters that have been filed by the defendant, Mr. Martin. We would state that on March 3rd, 2025, this court gave Mr. Martin exactly what he asked for, the deposition of Ms. Cordova before any ruling on our pending summary judgment. For 13 months, Mr. Martin did nothing. The only thing that woke this case up was plaintiff's recent motion, noticing their renewed motion for the hearing on the summary judgment that's been pending since March of last year. 16 days later, a single envelope arrived at my office via U.S. mail containing a deposition notice from Ms. Cordova, written discovery, and a scheduling motion. and a motion to disqualify all of Ms. Cordova's attorneys, including myself. Every motion that Mr. Martin brings today through Mr. Olson is a piece of that same package, and it has one purpose: to make sure this court never rules on our motion for summary judgment. This case was filed in December of 2020, and the Cordova family, a widow and 2 children, is entitled to a ruling. The basic issue before the court is that Mr. Martin asked for discovery. He was awarded and got the discovery, and then he abandoned discovery. The first I want to state is that there's a motion by the defendant to continue this hearing. Procedurally, that's dead on arrival. There was no accompanying affidavit filed under Rule 5607, and that states that relief is available only, quote, should it appear from the affidavits of a party opposing the motion, end quote. Mr. Martin filed a motion in a memo signed by his attorney, but no affidavit from anyone. That alone ends the inquiry under 5607. The premise is also false. Ms. Cordova did not fail to appear without justification. Rule 3704 states that non-attendance may be excused where a party has, quote, applied for a protective order as provided by the Rule 2603. The plaintiffs here have obviously done exactly that, and the motion is before the court today. The deposition notice itself for Mr. Olson was defective and unilateral. It was served by U.S. mail only. Later on, I will say, just before this hearing, he did follow up and send an email, but this has been a recurring problem where Mr. Olson will not send us emails, and he sends us the motions via mail, even though we've asked for this repeatedly since the beginning of litigation. He set the deposition of Ms. Cordova at his own office in Clarksville. He did it on a date the plaintiff's counsel was unavailable, and he had made zero effort to confer. Fourth, any discovery deficiency is entirely self-created. 13 months of total silence after this court granted his request in March 3rd of 2025. And respectfully, Mr. Olson nor his client can manufacture a Rule 5607 continuance out of their own delay. And we've cited in our briefs the Rye case, and that the focus is on the evidence actually presented, not hypothetical evidence. We also cite the Bird case that requires an adequate opportunity for discovery, but he had 13 months plus the original 5.5 years this case has been pending. His own filings also contradict this claim that the need for this deposition is essential. Mr. Martin's May 2026 filings say Ms. Cordova, quote, had no real involvement and, quote, suffered no money damages. That Mr. Martin cannot simultaneously claim her testimony is essential and then and that our renewed motion for summary judgment just rests completely on his admissions, not her testimony. Nothing she says can unadmit them. Fourth, defendant's motion to disqualify defense counsel under Rule of Professional Conduct 3.7 is unavailable and should be denied. The threshold rule of Professional Conduct 3.7 is a trial rule, and it states, quote, a lawyer shall not act as an advocate at trial, end quote. It does not bar pretrial or motion advocacy, and whatever else happens, counsel may argue every motion today. The disqualification is a drastic remedy granted with considerable reluctance only when no other practical or alternative exists, end quote. And we're citing the Cars LLC versus Ogle case, and that's found at Tennessee Appellate Lexus 140 at page 32. That case really represents the movement. Mr. Martin bears the burden of proof, and courts will scrutinize late tactical motions like this one with particular care. And it was only filed in response to our effort to renew our motion for summary judgment. But practically speaking, no lawyer here for Ms. Cordova is a necessary witness. Testimony is only necessary if it's material contested and unavailable or unobtainable elsewhere. The dispositive facts for the plaintiff's case for for our motion for summary judgment come from A, Mr. Martin's own sworn deposition admissions, and that was during his November 23rd, 2021 deposition. And we've cited in our brief that those are pages 151, line 16 through 23, page 153, lines 2 through 16, where he states that under Rule 1.5C and 1.5E, he committed ethical violations. B, the Court of Appeals, their findings, they found that he had abandoned and that the plaintiffs were the prevailing party against his claim for the lien. And the court records, they're all cumulative proof sources, and nothing requires any of the attorney's testimony. The motion is also entirely conclusory. It recites the counsel or witnesses with regards to the representation of Cordova, end quote, and to quote, the pertinent matters set forth in this action, end quote. Paraphrasing the rule is not the particularized showing that the rule demands. Mr. Martin and Mr. Olson, as his attorney, identify not one specific fact obtainable from only counsel. Every exception applies to this matter, that the chronology representation of the facts are uncontested. A2, that the fee-related testimony is expressly protected. That's the nature and value of legal services cited under the rule. A3, also under substantial hardship. We're 5.5 years in. We have 3 attorneys that have worked consistently on this case since its inception. And on the eve of a dispositive ruling, they make this motion. That's the definition of the hardship. And then Rule 3.7b forecloses blanket disqualification. Firm level disqualification requires a rule of professional conduct 1.7 or 1.9 conflict. None is even alleged here. Timing also just tells the story, Your Honor. In closing, the defendant has known who plaintiff's counsel are since well before this case was filed, all the way back to 2014. 2020 was when this specific malicious prosecution action was filed, and this motion only appears on the docket on May 14th of 2026, 16 days after we renew our motion for summary judgment. And I just want to quote Mr. Martin, the motion to disqualify. It said, quote, in an effort to come, counsel believes bring pressure to bear, Cordova's counsel sued in this civil action, Robert Martin. The motion is counter pressure admitted on its face. Quote, he also says, it is my desire to conduct a discovery of deposition of each of you. And this is Mr. Olson's letter to us. I'm moving this along quickly at this point. Mr. Rich noticed me to a hearing very quickly. That's this one. And Your Honor, I will just state as an intercalary, we got our signals crossed when we contacted the clerk's office, and we originally set this matter for before Your Honor by interchange, which we thought was available through the clerk's office. And then we were informed that Your Honor didn't have it. You didn't hear motions by interchange, and that original matter was incorrect. So we revised and sent in and filed a new notice placing this hearing for today's docket. So we didn't file anything without, this is the date for motions, and this is the date that we were intending to file it on. So the issue with the quote is basically in his cover letter that he's conceding that his entire package of these motions, the discovery and everything else, is just a reaction to our renewal for the motion for summary judgment. Finally, defendant's motion for sanctions, there's nothing to hear. No motion exists. Only a notice of a hearing related to motions for sanctions, end quote, was served on us on June 26th of this year. No sanctions motion has actually been filed with the clerk to our knowledge and served on the plaintiffs. And Mr. Martin's own filings prove it. The motion to continue, quote, reserves the right to move the court for appropriate sanctions. And the memorandum attached, quote, reserves all rights with respect to file a motion for sanctions under Rule 37. One does not reserve the right to file a motion that's already filed. So that hasn't happened. Rule 702 requires a motion stating grounds with particularity. Due process requires notice and an opportunity to respond before sanctions are considered. And we ask that the court decline to hear it and strike the notice. If the defendant ever files a real motion, we'll prepare a full briefing and respond. On the merits, it would fail anyway. Rule 3704, a non-appearance is excused where a Rule 2603 protective motion has been applied for, and it has in this case. To just touch on plaintiff's motion for protective order, the 26.03, the good cause is overwhelming. 13 months of inaction after the leave was granted by Your Honor in March of last year. B, there was mail only service that compressed the response window to 14 days of actual receipt with no attempt to even confer with us on setting the deposition. It was set at counsel's office unilaterally on a date we were unavailable, and also while we had that pending dispositive motion set for this date. Rule 2603 states a court may make, quote, any order which justice requires. We cited a couple of cases, the Jackson and the NHC Nashville fire litigation case, citing the inherent authority of the court to prevent discovery abuse. And the relief we're requesting specifically is one that we quash the 5/14/26 notice of deposition on my client, that two, that her deposition be found by the court, as we've previously requested, to be unnecessary based on the admissions of Mr. Martin. And that number three, that Mr. Olson be directed on behalf of Mr. Martin to serve all future papers on us contemporaneously by email or fax. So there's not this thing where we receive motions and postmarked envelopes that are far after the date that's reflected in the date of service. And that, prejudices our ability to timely respond. So finally, with our renewed motion for summary judgment, we ask the court grant that. And this is the main matter that's before your honor. The standard is of malicious prosecution is one, prior proceeding instituted without probable cause. That's here. Number two, with malice, and three, terminated in plaintiff's favor. And we've routinely cited the Christian versus Lapidus case in our briefing, the Parrish versus Marquis case. And the defendant ironically cites these exact same cases as for their response. So after adequate time for discovery, the focus is, quote, on the evidence the non-moving party comes forward with at the summary judgment stage, not on hypothetical evidence. The non-movement must do more than show, quote, some metaphysical doubt. And I'm citing the Lapidus case. Ground one, forfeited discovery, adequate time. The case was filed in December 2020, 5.5 years. The MSJ has been pending since September 19th of 2024. That's 21 months at this point. The court deferred the ruling on March 3rd, 2025, solely so the defendant could depose Ms. Cordova. For 13 months, they did nothing. And under Rye, adequate time has passed. The record is what it is. And, quote, he asked for it, he got it, he abandoned it. Ground two, the opposition on 2/24/25, that's back in last year, creates no genuine issue. The preamble of Section 21 misses the claim. Plaintiffs do not sue Mr. Martin for violating the rules of professional conduct. The plaintiffs are suing for the common law tort of malicious prosecution. Mr. Martin admitted violating rules of professional conduct 1.5C and 1.5E, which are evidence on probable cause. Section 21 of the rules of the rule itself states a violation, quote, may be relevant in determining whether there was also a breach of the applicable standard of conduct, end quote. His own authority, Mr. Martin's own authority, concedes that point. The affidavits of Mr. Martin and his assistant, Ms. Hockaday, don't create any factual issue. Even accepting that Ms. Cordova orally consented, as Mr. Martin claims, to his involvement, oral consent is not a legally enforceable contingency fee arrangement under Tennessee law and cannot supply probable cause for a lien. The Court of Appeals has already foreclosed this and found, quote, all the services Mr. Martin subsequently rendered inured to the benefit of the plaintiff. He never had a fee agreements with plaintiffs, only with Mr. Hodges. And I'm citing from the third page of the Court of Appeals findings. An affidavit restating a rejected legal conclusion is not evidence, Your Honor. Also, he misreads the White versus McBride case in the flagrant analysis governs whether an attorney forfeits any fee. It says nothing about whether pursuing a lien with no fee agreement was supported by probable cause. Hodges' estate recovering a fee does not give Martin probable cause for his own lien. Malice is his only evidence is, quote, in the motion that he argues is, quote, I never acted with malice. It's just a statement he continually makes. And bare conclusions don't defeat summary judgment. Malice is inferred from want of probable cause and improper motive. Ill will is not required. We cite the Cohen versus Cook case, 462 Southwest 2nd 502, and that's a Tennessee Court of Appeals case from 1969. We also cite the Howell versus United Rentals case, which is a 2023 Tennessee Appeals Court case found at Lexus 374. Course of conduct, the approximate 6-year lien pursuit by Mr. Martin, despite knowing that it was unethical and he had no written agreement to pursue it. And then subsequently after that, through Mr. Olson, he filed a second retaliatory suit against Ms. Cordova and all of her attorneys. He filed that case on November 4th, 2022, and then voluntarily dismissed it after a 13-month stall. Damages were being dragged through baseless litigation is the injury to Ms. Cordova. Ms. Cordova retained counsel, appeared, and defended the lien claim that he brought for more than 6 years. And we cite the Myant case, that his quote, "between attorneys only" framing also contradicts his claim that he needs her deposition on damages. And then finally, he admits the favorable termination. It's admitted. The defendant's responses to undisputed facts 4, 5, and 6 in this summary judgment are all admitted, that the lien claim terminated when Mr. Martin abandoned it after pursuing it since July of 2014, and that his later suit against plaintiffs and their counsel was voluntarily dismissed. So we would respectfully ask that the court award us the summary judgment, give us the judgment.
The courtroom grew tense as both sides fiercely argued over whether a punitive damages claim should be allowed. The defense insisted the evidence was too weak and warned that the amendment would unfairly expand the case. After listening carefully, the judge challenged the defense's concerns by proposing a balanced solution. Instead of denying the motion, the judge allowed the punitive damages claim to move forward while blocking financial discovery until stronger evidence was presented. This decisive ruling protected both sides' rights and completely changed the direction of the lawsuit, proving that one judicial decision can reshape an entire courtroom battle.